This is number 5 on the probation calendar, Mr. Beatles.
Okay,
Your Honor, he's on the main calendar, as numbers, let's see.
1 and 2.
Please is he number 5 on the, Beatles, number 5 on the main calendar?
Yes, number 5 on the main calendar and 1 and 2 on the probation.
okay. Let me see. Position 5 on the main calendar. Yes. This is a new arrest from March 16th, 2024. Okay. And then he's on the probation revocation matter, positions 1 and 2. And looks like it's for a DUI and expired license. So your call, Mr. McLean, which one would you like to address first?
The main calendar, Your Honor, I put that down as a non-negotiated plea.
Okay. Let me see. What's the non-negotiated portion?
Just the amount of extra days. He would like it to be as close to 0 or 0 if possible. But as it stands, the 60 divided by 2 would equal 30. 30 minus 11 would equal 19. So that's a bit of it's almost 3 weeks into the future, and he would like to not have that.
With all due respect, I'm going to start with the probation revocation matter first.
Very good.
Okay. Mr. Franklin Gregory Beatles has got a probation revocation matter from a 20 case from 2022. Mr. Beatles, you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and Mr. Michael McLean will be representing you in all your cases held today. On the probation revocation matter, the original case was 22 CR 4391D, in which you were convicted of driving under the influence of alcohol less safe and or expired or no license on person. With regards to the probation violation case, that's 24 PV 459. Officer Barnes, what were the terms of his disposition, and when was he convicted, and what's the reason for the revocation?
Mr. Beatles was before the court on January 27, 2023 for the offense of DUI alcohol less safe. He was sentenced to do 12 months of probation, report and pay supervision fees, complete a drug and alcohol evaluation and risk reduction course, the victim impact count of 40 hours community service, and pay a fine in the amount of $671. Your Honor, this is Mr. Beatles' third revocation hearing. First one was held on June 13th of 2023. The second one was held on February the 13th of 2024. And at that time, that hearing was reset to February the 27th of 2024, where Mr. Beatles did not appear. At this time, Your Honor, Mr. Beatles still has an outstanding balance of $671 on the fines. 40 hours of community service has not been completed. The risk reduction course, drug and alcohol evaluation, nor the victim impact panel has been completed. At this time, Your Honor, it's 80 days remaining left on this particular case. Because of this is Mr. Beatles' third revocation hearing. Probation respectfully asks that 30 days be revoked and the balance be suspended.
All right. Mr. McLean?
Your Honor, if that were something closer to a week, that's probably enough time, sufficient time for him to reflect upon this matter. Consider the 30.
I'm inclined to do just revoke the 80 days and give him credit for time served. Nothing suspended. That's where I'm going, Mr. McLean, unless you have something to add.
Well, Your Honor, let's see. He is going to be taking a FVIP class as soon as he pleads on the other case. He has job interviews as a custodian to do maintenance. He's capable and skilled at landscaping as well. He's going to be working pretty hard, and the longer he stays in jail before he gets to that, of course, he will be at a disadvantage. Spring is on, and a lot of his landscaping jobs are going to be taken up right away. But he would like just a chance at that, Your Honor.
Your Honor, if I may, please.
Mr. Barnes, yes, sir. He's been in
Yeah.
custody for 11 days, just FYI.
Okay, thank you, Your Honor. Your Honor, Mr. Beadle has shown probation that he's not willing to comply with any of the court's orders by missing those 3 revocation hearings. At this particular time, probation does not feel that Mr. Beadle is a good candidate for probation at this particular moment. We've given Mr. Beadle 3 opportunities to comply with the initial orders of the court from his first case, and again, he has not completed any of the conditions or made any attempts to complete any of the conditions. That's and again, that will be our insight for Mr. Beadle moving forward, Your Honor.
On the probation revocation matter, the court is going to revoke his probation. This is going to be recorded as a probation violation. It's going to be revoking 80, he's got 80 days remainder. He will serve the 80 days, given credit for the 11 days, after which then this case will be closed out. Mr. Barnes says nothing suspended. Is revoke probation to serve out the remainder of the 80 days, credit for times served 11 days.
Yes, ma'am.
All right. Mr. McLean, that means your client has, and you can correct me if I'm wrong, he has about 27 days left. No, 26 more days left.
Right, Your Honor.
29, excuse me, 29 more days left to serve in jail.
In light of that, I think that the main case plea resulting in 19 extra, if it ran concurrent, would not then further burden him, and that would probably be a negotiated plea.
All right. Mr. Beadles, I have revoked your probation for absolutely failing to comply with probation at all. And even to the point that even probation doesn't want you. They consider you to be not an appropriate candidate for probation. In light of that, given that information, would you like to consult with your client, with your attorney, with regards to whether you want to proceed with the plea on the battery family violence matter?
Yes, I can talk to him.
All right. Mr. McLean, looks like you are alone in courtroom 2. I'm going to put courtroom 2 and jail court iPhone in a breakout.
We have inmates against over here by the wall, Your Honor.
Oh, you do? Okay. Then
I'm about to take him out, Your Honor.
okay. All right. Miss Grace, if you can place courtroom 2 and jail court iPhone in a breakout.
Yes, ma'am.
A few moments later.
All right. Mr. McLean in courtroom 2. Is it? If courtroom 2 could please start that video.
Trying to get those on.
Okay, you're on. Thank you. All right. So, Mr. McLean, your client's going to be spending a little bit more extra time at the jail. And he's got a signature bond through pretrial on position 5. What would your client like to do?
Your Honor, he would like to plead guilty and make a negotiated plea this time.
All right. Mr. Pierre Thomas, we're going to address position 5. This is again Franklin Beadles, case number 24 CR 1245D, in which he's accused of battery, family violence, and battery against a female who is pregnant from March 16th, 2024. Mr. Beadles, you've been advised of your right to remain silent. Your attorney is Mr. McLean. May I place you under oath for purposes of the plea?
Yes,
The other right hand? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
yes, ma'am.
Thank you. Mr. Pierre Thomas, after you've heard probation's recommendation, what would you like to recommend?
The recommendation from the state on count 1 battery family violence is for the defendant to serve 12 months on probation, to serve 60 days in custody. Credit for the 11 days that he's already served. It looks like he was booked in on March 16th to March 26th, which is today, for the balance to be probated, for him to have no further contact with Miss Nakie Page, Nakiepage, for him to stay away from Atlanta, Georgia, for him to complete a family violence intervention program, to submit to alcohol, drug evaluation and treatment as necessary, for him to complete 40 hours of community service, and for him to have no firearms. As it relates to count 2, battery against a female who is pregnant, for him to serve 12 months on probation. That is to be concurrent with count 1. I do believe that Miss Page is on, so if we could sound for her in accordance with Marcy's law, that'd be greatly appreciated. Our office has been fortunate enough to contact her, or be in contact with her. She does agree with the plea offer per our last communications. And so if we could sound for her, but if we could also get the defense to stipulate to venue, factual basis, and ID, that would be greatly appreciated as well. Nothing further to add from the state at this time.
Mr. McClayton, does your client stipulate to the factual basis, venue, and ID?
Yes, Your Honor. Could I mute and just have a moment to consult something on my email?
Okay, go
Thank
ahead. Miss Nakie Page, if you'd like to contribute to the proceedings.
My name is Nakia, actually. And
Okay,
I know this isn't normally him. I know he's been going through a lot lately, which isn't a reason or an excuse, but the no contact order is not going to work for us, given that we have a 7-year-old, a 3-year-old, and I am currently pregnant with our 3rd child.
and the allegation of this incident apparently involves an alleged assault upon you in your current state.
Yes,
So
ma'am.
what are you asking the court?
I don't want the no contact order because my children are already missing him.
All right, that's one factor to consider. Anything else?
That's it.
So the children are missing him,
Yes.
but not you.
No, it's been
Incidentally
11 days. It's been 11 days, and he's a active father, active uncle. He takes them to school, so I've been having to adjust my schedule, and I have adjusted to so far as my children, they're asking me every day, and I have no answer to give them.
And has Mr. Beadles legitimated the 3 children that you share with him?
We have one that is legitimate, and then I am pregnant with the second one that will be legitimate.
What do you mean when you say legitimate?
His name is on my second son's birth certificate.
Okay, that is not legitimation in the eyes of the law. In the eyes of the law, Mr. Beadles would have to go to Superior Court, file a legitimation action, and get a court order to establish that he not only has the father of the 3 children, but that also he has rights to have visitation and custody over the 3 children, including child support. That's what legitimation means. The name on the birth certificate does not give him any rights. Do you now understand what legitimation means?
Yes, I still
Okay.
need him to see my children.
Understood. And what comes across very clearly is that he needs to have contact with the children, which is why I'm discussing legitimation.
So is that something that we need to, that I
Not
need to
you,
do?
not you. You don't have to do a thing.
Oh,
That's all Mr. Beatles. If he wants to see his kids who are missing it, he needs to file the action in Superior Court. And that way he has a court order that says that he can see his children on specific schedules. And that way they won't miss him and he won't miss them. Understood?
alrighty, I have to get back, so thanks.
Okay. Thank you for your input. Mr. McLean, are you ready to proceed?
Yes, Your Honor. What I was checking on was I have an apology to make to Mr. Beatles. I had said that count 2 was going to merge. It simply says 12 months probation concurrent with count 1. I had misread it, so I apologize to Mr. Beatles. It does not merge. It's just going to be probation running concurrent with no further special conditions. So it's kind of similar in effect, but it will be on his record, and I will have to write it down on the face sheet of what he is pleading guilty to.
All right. Mr. Beatles, if you decide to move forward with this plea, you would be pleading guilty to battery, family violence, and battery against a female who is pregnant. 2 very serious charges. Even though they're misdemeanors, they're very serious, because once they get on your record, it will be on your record if in the event anybody chooses to look at it. Furthermore, if you get arrested again for battery, family violence, it will automatically be a felony charge. Given this information, would you like to speak with your attorney and/or would you like to move forward with the plea?
Move forward with the plea.
Mr. McLean?
Yes, Your Honor. We'll move forward with the plea.
All right. So do you so stipulate to the factual basis, venue, and ID?
We do for the
All right.
first plea, yes.
Mr. Beatles, have you consumed any medicine or alcohol recently?
No, ma'am.
And have you understood the proceedings so far?
Yes, ma'am.
Have you understood the discussion I had with Ms. Page with regards to the issue of contact with your children and legitimation?
Yes, ma'am.
And do you understand that you would have to file a legitimation action in order to see your children?
Yes, ma'am.
Okay. Are you satisfied with your legal services?
Yes, ma'am.
And is anybody forcing you or inducing you to take a plea today?
No, ma'am.
If you decide to plead guilty to battery, family violence, and battery against a female who is pregnant, as I've explained to you, that any subsequent arrest for a similar offense will automatically be a felony charge. Do you understand that?
Yes, ma'am.
Are you still willing and to enter into this plea voluntarily and knowingly?
Yes, ma'am.
Please understand that if you plead guilty today, you will not have an opportunity to a trial before a judge or a jury. You will not have the assistance of counsel to go back to court, to confront your accuser, challenge the evidence and witnesses brought before you, present your own defenses, arguments, and mitigating factors, and also waive your right to have the state carry its burden to prove the charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
How do you plead to 1 count of battery, family violence?
Guilty.
How do you plead to 1 count against a female who is pregnant?
Guilty.
Mr. Beatles, I'll accept your guilty plea. I'm about to sentence you. You've already heard from probation officer Jakai Barnes that you are not a good candidate for probation. Do you understand that you're required to report to probation as the court directs? You're required to complete all these conditions. You're required to pay your probation fees. You're required to take classes. You're required to do community service. And if you don't do any of that, you will get a probation revocation, as you've just observed in your other cases. What is your opinion on your ability to comply with probation this time?
I'm going to do it.
And if you don't,
I see.
I want it on record, Mr. Beatles. I want it on record, Mr. Beatles. What happens if you don't?
I'll be back here.
No. On record, I want you to agree that if you violate probation 1 more time, that you are willing to serve out the rest of the year in prison, day for day, no 2-for-1 benefit.
Well, I don't know that he has the legal ability to agree.
No, he already knows that he's already violated probation. He already knows that he failed to attend his probation revocation hearing twice. And we just had a probation revocation hearing, and he knows that if he violates probation, he would have to serve the rest of the time out in jail. So I want him now to understand that before I sentence him to probation, he understands that if he violates probation one more time, that he agrees to go back to prison and serve out day for day the rest of the time in this case.
No, I'm not trying to argue with the court, but Your Honor, some revocations vary in their severity of what caused the violation. So he cannot agree in advance to the appropriate punishment because.
And this plea is not moving forward.
Understood.
So Mr. Beatles, it's up to you right now.
We can put this on the jail jury calendar. That's fine.
All right.
I understand.
Mr. Beatles?
I understand.
Your Honor, he can
Your attorney is saying that you're pleading not guilty and scheduling the case for trial.
yeah, he just can't. He can't agree to that last statement, Your Honor. That's the only problem. So let's just put this on the jail jury and move on.
Mr. Beatles, it's up to you. You have the final decision whether you want to move forward with the plea.
I'm going to be withdrawing as counsel. I will not participate in that.
Okay.
So I think the best thing to do is to put it on jail jury. If I'm in conflict with him, then he could get a conflict defender. That's fine.
All right, then in that case, I amend my request. Mr. Beatles, do you understand that if you violate the probation and I get your revocation hearing, I'm not inclined to reinstate your probation. Do you understand?
Yes, ma'am.
Is that satisfactory, Mr. McLean?
Yes, Your Honor, it is. Because Your Honor has stated an inclination, which Your Honor certainly has the right to do. That's just that it has to be a fresh look if he does violate.
I'll consider that, but right now, I'm not happy with the way he has responded to the prior court orders. Mr. Beatles, you are on notice. Right now, on the battery family violence, the sentence is 12 months to serve 60 days, credit for time served 11 days. Balance probated. You are to have no contact with Nakia Page. You are to stay 200 yards away from Nakia Page. You're not to communicate with her in any way, form, or manner. You are not to communicate with her through a phone, a computer, or anything to the effect, with one exception. Once you get your legitimation court order to visit your children, then you may communicate with her through a third party with regards to a transfer of children, unless the Superior Court says otherwise. Do you understand?
Yes, ma'am.
You are to stay away from 1991 Delow Drive. You're not to return to that location at all. After you've served out the additional jail time for this case and your probation revocation case, you will report to probation on the first available business day. Immediately after you're released, you're to report to probation on the first business day, which will be on Monday, Tuesday, or Thursday. And you must report before 3 p.m. You'll be reporting to probation twice a month, not once a month, twice a month.
Okay.
While you are reporting to probation, you will complete a domestic violence intervention program. You must enroll in that program within 45 days of being released. Do you understand? And as soon as enrolled, you are to attend those classes every week for the next 24 weeks. Within 30 days of reporting to probation, you are to complete an alcohol and drug evaluation and submit yourself to any treatment. You're not to consume any alcohol, you're not to consume any illegal drugs, and you're not to possess any weapons and any firearms. You're also to complete 40 hours of community service, and you are to begin your community service within 30 days of being released with a completion of 10 hours per month. Do you understand?
Yes, ma'am.
These are very strict requirements, Mr. Beatles. Don't set yourself up to fail.
I'm not.
With regards to your conviction for battery against a female who is pregnant, your sentence is 12 months probation concurrent with count 1. You are to have no contact with the children you share with Nakia Page. You shall file a legitimation action with the appropriate superior court and get a superior court order to give you rights for visitation, joint custody, and child support. And it's up to superior court whether they will allow you to have contact with Miss Page in order to transfer the children. Do you understand, Mr. Beatles?
Yes, ma'am.
I'm not happy putting you on probation because I agree with Officer Barnes, you're not a good candidate. So my challenge to you is to prove me wrong.
Okay.
Thank you.